We're on standby.
Oh.
We're live. Okay, thank you, Lindsay. Good evening, everyone. Thank you for being here. My name is Angela Arsenault, representative from Williston. I want to welcome everyone to tonight's meeting of the Joint Judicial Retention Committee. We're going to have everyone who will testify tonight. We'll swear you in a moment, all together, unless anyone objects to that. Okay. But first, I wanted to have us just quickly go around, introduce everyone, ourselves, and then we'll carry on.
Senator Terry Williams from the Rutland District.
Tom Oliver, representative for Sheldon and Swanton.
Alicia Millay, representative, Pittsford and Proctor.
Senator Brian Collmore, representing the Rutland District.
Hello.
Martine LaRoque-Ulick from the Chittenden Central District.
Evening, everybody. I'm Senator Ruth Hardy from the Addison District.
Hi, folks. Connor Casey from right here in Montpelier.
All right. So let's see what order we have. Okay. Well, funny enough, this binder that I forgot to bring. Oh, here it comes. Here it comes. It has my little oath and attestation written on a piece of paper inside the binder. Thank you so much, Terry. All right. There it is, right on top.
Just retaining a brownie.
All right, so I will ask all of our judges to stand, and you know how to do this, raising your right hand. Do you swear that the testimony you're about to give is the whole truth and nothing but the truth under the pains and penalty of perjury, or so help you God?
I do.
Thank you. You should probably know that part, but we will start this evening, and we do have an agenda. I'm not sure if everyone has it in front of them, but we're getting a little head start, which is great. So we have about 30 minutes allotted to each judge, and we won't have a timer on, but it would be terrific to, we'll try to keep to something close to that, I'll say. Yeah, and I guess I do want to ask if there are any preliminary matters, since that's an agenda item that anyone needs to bring up.
Eric's not with us tonight. Right?
That's right. Our attorney, our alleged counsel, Eric Fitzpatrick, is not here tonight, but has assured us that if we need to call him, we can.
Okay.
Okay. So we're winging it without our trusted counsel. And we will start with the Honorable Elizabeth Mann.
Good evening.
Good evening. So we will, I should say as well, you probably know this, we'll start with your remarks, and then we'll each have an opportunity to ask a question and maybe a couple follow-up questions, but we always start with our guests.
Well, thank you very much. And really, that's, I think, where I'd like to start. It's by saying thank you to all of you for the work you're doing for Vermonters as legislators and for agreeing to serve on the Judicial Retention Committee. This is truly a valuable process. It's not necessarily always an easy one from this perspective, but I fully appreciate the option and the opportunity to receive feedback from attorneys and other court users, not only now, but now that we have it in the interim optional review process as well. I was able to take advantage of that opportunity the first time it was available. And I think it is truly a good thing to get more feedback. I think no matter how much we try, it's really challenging to get that from attorneys. And so having that as a formal process has been really helpful. And I hope that we're going to be able to continue it. While the comments that we get are few, what they do underscore for me is that one of the keys to continuing to improve our court process is ensuring that we have continuous open discussions with attorneys and other users of the court. In that regard, in almost every bench bar that I have, regardless of the docket and regardless of who's participating, and that can be attorneys, the Department for Children and Families, the probation officers, the guardians ad litem, diversion representatives. I ask people to tell me if they see things in the courthouse or in the courtroom that are troubling to them or that they see as a problem, whether it's something that I'm doing or whether it's a larger systems issue. And I do recognize that I am far from perfect, and I appreciate the perspective that they can share with me to continue to improve what's happening in the courthouse. I tell them that it may well be that I do things that I don't appreciate the impacts of, or that I just can't see. And unless they're willing to share that with me, I probably won't see it and it can't change. There is also the very real possibility that I'm engaging in activities for a very specific objective. And it's possible, and hopefully often the case, that those activities are achieving that objective, but that those activities may very well have ripple effects that I can't see, that make it more difficult for the attorneys or other people who come to the court. And I want to know about that because I never want to add to the burden of participating in the court process. It's also possible that I take very deliberate actions for very specific purposes, that unless we engage in these discussions, they won't understand why those actions have been taken, why a change has been made, and what the other added or other values of that change may be. If we work together, we can capitalize on what's working right in our system. We can work together to address any problems that we identify. I do believe very firmly in good communication and working together. I have an open door policy, and I've always had that with respect to staff as well as to attorneys. So when I read some comments that came in from attorneys who left with a less than positive impression of the court process, it was tough. Those comments really stick with you. They leave a mark. And I have to say, they kept me awake many a night since then. It's also compounded by the fact that they're anonymous, which I appreciate. But at the same time, there's nothing I can do in terms of speaking with whoever wrote it or them and to better understand what led to that impression of the court process. So it really hinders addressing things, which I think is something we should all always be striving for, is that better communication in the moment. The comments also highlight for me the need to really look for new methods of fostering that ongoing and regular communications with attorneys and other court users. I do think that this has become far more difficult in the post-COVID era. While we are having in-person hearings, in many of our dockets, we still have a large number of remote hearings. We still have a large number of hybrid hearings. And almost all of our, at least in the courts in which I practice, bench bar meetings are remote. And there's a great convenience to that. It certainly gets some added participation in terms of attendance, but it comes at a cost. And that cost is that we lose the organic discussions and the free exchange of information that often happens when we're in person. So as a result of this process, I spent a lot of time trying to identify whether there were different ways that I could start to get more of that communication in the moment, or at least very close to it. And I think I've come up with a number of different practices that I can employ. And I plan to sort of roll those out in the next couple of weeks and we'll see if it works. I remember when I first started in Windsor County, I tried to put out a suggestion box for comments, and that didn't really work well, except for maybe some participants or litigants who said things that maybe weren't helpful. But the attorneys just weren't participating in that. So I'm hopeful that these are things that will be far more proactive and hands-on, and we'll get that better communication. Part of my daily process every day, beyond just working to maximize our utilization of available court hearing time and working to expeditiously process orders that need to be processed for those hearings, as well as the myriad of filings that we get in the computer queues, is to take time at the end of the day, usually on the drive home, to reflect on the day's hearings. And in doing that, to assess what worked well and should be repeated, as well as to identify things that could have been improved, and to identify specifically what to do next time in that scenario so that we're getting a better result. This has always been a part of my process, and it always will be, because my goal each day is to be a better judge today than I was yesterday. I think you do need to always strive to improve. This is a challenging and a demanding job, but I truly believe in the importance of the judiciary as a process for the people. I love working with people to resolve their differences where that can be accomplished, and to providing them with finality and a way to move forward when agreement is not an option. Since last retention, I had the very good fortune to serve as a treatment court judge for 5 years in Windsor County. And I know that Judge Griffin was here last week, and he is certainly a champion for continuing a strong presence for treatment court in Vermont. And I would echo that. I think it's an amazing resource, but I do want to take it one step further. I think that in all of our dockets, we can apply positive and successful practices from the treatment court dockets to get better results in those other dockets. Just one example of that is the use of positive recognition. And this goes well beyond recognizing steps towards sobriety or actual sobriety, but to recognizing the very simple things that someone is engaging in a court hearing, that someone has shown up for court, which is something that happens a lot less frequently than it should. Recognizing when former partners are able to co-parent effectively for their child, and also recognizing that even when those former partners are in a dispute, that you find the pieces that are working, and you tell them that they have a child who's very lucky, that they have two parents who are not only very present and involved in their lives, but they have two parents who are willing to come to court, which is never a fun process, and fight for what they think is right. And I do firmly believe that when we recognize the positives, it generates more positive results. And hopefully, I think we all need more positives these days, and hopefully those positive results help to bring parties together and to move forward with the need for less litigation. That I can't really document, but I'm hopeful. The practice of recognizing those positives is something I definitely employ across the dockets. But this process caused me to reflect a little more and realize that while I do it with attorneys, I don't do it nearly as frequently as I might. There's some challenges there, obviously, because you can't look like you're in favor of one party or they're a counsel or anything like that. But there are opportunities to, at the end of a hearing, recognize what's gone well, when parties have been able to streamline the process, for instance, by stipulating two exhibits that could be agreed upon and leaving, on a limited basis, points where we really need to fight. Those kinds of things, I think when we recognize them more, we'll get more of it, and little changes that can help to facilitate a smoother process and hopefully a better one for everyone. So I'm hopeful that you will allow me to continue on this path. And I'm grateful for the opportunity to answer any questions that you may have this evening.
Thank you so much. Why don't we start with Senator Williams? We'll come around the table this way.
Great. Thank you, Your Honor, for your
Thank you.
testimony. That was very compelling. And as I went through this bracket, I saw words like respected, excellent, leader, does not allow disrespect in a court. Those are all good qualities, and when you get that from the attorneys that you work with, I think that's great. So I thank you for your service, and I have nothing else to offer.
Thank you.
Thank you, Judge, for being here. I see in the last 5 years, you've worked your way around the southeast corner pretty well. In a lot of different courts and different courtrooms. And you may have had a few comments that you didn't care for, but you also had some very good things. You like to figure out what works for you or what works for your hearings. Tell me what works.
What works is clarity. I think it's really important. I try to minimize status conferences. I don't like to have status conferences where people come in and they say, oh yeah, we're working on it, we'll come back. If they need an update type of status conference, I ask them to put it in writing. And then I can review it. We don't have to report time, they don't have to travel, we move forward. But I do schedule regularly a pre-trial conference that is about a month ahead of any contested hearing and is designed to ensure first and foremost that they haven't reached an agreement, to clarify whether they may have an agreement, to identify any issues that are going to need court involvement. And so that we can get those rolling, because to me, one of the most important is all of that preparedness from the litigants as well as from the court, so that when we show up for that hearing, whether it's scheduled for 2 hours or a full day, whatever it is, that we are going to maximize the use of that court time. Because I know that if we show up and start going back and forth about things that could have been resolved, we're eating up that evidentiary presentation time. And when we do that, we get to the end of the day and they say, we need 2 more hours. Well, 2 hours isn't something that you just say, oh, come back tomorrow. You have now delayed the resolution of that case, depending on the courthouse that you're in and the particular docket, easily by up to 3 months, sometimes longer, depending on how much additional time you need. And so I know it's an old cliche that justice delayed is justice denied, but I think it is so very true. And that it's really important to do everything we can and make sure we use that time so we get to the resolution. I think it's really important that once we've ended that hearing, that orders come out expeditiously. So it's a word I use frequently, but it is really important. If you've heard a divorce and you don't issue a decision for 6 months, 8 months, by the time you get there, they may have had a lot of factual changes and your order may have really limited impact because they're all ready to come back with a modification. Whereas if you had issued it timely, they would have begun working with that order and may not need that modification. those are just a couple of examples, but I do also issue, in almost every hearing, I do a judicial entry order, and I identify what we did in the hearing, what the next steps are, and what our next hearing is. And I do that because I feel like it clarifies for the parties what I heard in the process. If I heard something that they're like, hey, you know, this isn't where we thought this was, they can let me know. Fortunately, I don't think that's happened yet. But it also gives them a very clear roadmap for what the court is expecting to happen at the next layer.
Thank you very much.
Thank you.
Hi. I guess I don't have any questions. I had a question that was, you already answered. So, most of the responses are good, and the ones that seemed a little harsh, it did seem like you kind of demonstrated or that you reflect on the drives home. And I'm just wondering what else you would do to kind of, I guess, give yourself time to maybe do something differently the next time.
I think it really is identifying when things happen. And one piece really comes back for me is that I had an individual on a remote hearing, which can be a little more challenging. And he was constantly speaking over the other party. And when I tried to sort of redirect that, it was going nowhere. And only later did I learn that a lot of times with the remote processes, if they're talking, they can't hear you. So when you try to let them know that you've interrupted somebody and it's not your turn to speak, they can't hear you. So for me, one of the changes there was to make sure that at the outset of hearings, I try to make a better expectation list for people about when to speak, and how that's going to happen. But it really varies a lot. And, sometimes it is as simple as saying, I should have taken a different approach 3 steps back. And it's just trying to constantly refine the process.
So one of the points I made, I think last week, it seems to me that the lawyers, the attorneys, have a tendency to hold judges more accountable in some ways than the staff. I think that's pretty evident in the comments that we got. All 13 of the comments that were given to us by the assistant judges and the staff were positive. There was not any negative comment. I guess I'm struggling to understand why words like unkind, hostile, and rude, they're all personality traits or maybe lack of trait. I don't understand, I guess, how I understand the process has a winner and a loser in most cases. And I think that plays into why someone might feel more strident in one case. I'm struggling to, you're none of those things, I don't think, as you presented. And I was happy to hear that it bothered you to the point where, you thought a lot about that. So I'll just throw that out there.
No, it's tough. Unkind and rude, I don't know where it came from, but like I said, and I do try to encourage people that if they have a problem, that they're gonna talk, and I appreciate why they might not. But we've gotta fix that, and I don't know. I don't know what prompted that. I will say, I will own one definite piece that I do is, but I've never had bad feedback in the hearing in terms of what somebody's reaction to it was. So I don't know if this is something that I did with that particular person that they just didn't like. But sometimes attorneys, and I might have been guilty of this as an attorney too, you really want to drive home a point. So you keep asking the same question over and over and over and over. And so sometimes I will say, excuse me, I just want you to know that the court has heard that the testimony from this witness is X, Y, Z. And oftentimes they'll say, oh, well, thank you, Judge. Now that we know you've heard the point, we'll move on. That's one thing I can think of that somebody might have taken in the wrong way. I don't know.
Okay, thank you, Alice.
I wanted to ask you a question about your statement that accompanied your intention to be retained. On page 4 of that statement, you mentioned some of the underlying, what you call the underlying problems that we're facing, drug addiction, mental illness, family dysfunction. And then you said, while the core values of the court system will remain unchanged, our methods must always evolve to meet changing societal issues. And I agree with that statement. And I'm very curious to hear if you think we are succeeding in doing that. And if so, how? And if not, what's missing?
I am, as I've already said, a huge fan and advocate for the treatment courts. And I think those, obviously, they don't solve the broad problem because you can only address a limited number of people in them. But as I said, I think that you could try to employ those same tactics. I think that's a change of process that we can use. I think that particularly in the family division, where you have the domestic docket and the juvenile docket, those pieces are really important. Recognizing that and just talking to people and trying to get them to identify where their problems are. Because I think one of our societal issues is that we seem to be failing in our own personal problems. And so if there is a way between two parents, as an example, to find the way to facilitate their communication. And they have these great apps called Talking Parents and My Family Wizard and things like that. And I really encourage people to try to use those so that they may be able to sort of break free. They also have these great things called tone filters. So if you type a text or an email or whatever, a message to your spouse, it looks at it and it says, oh, you may not want to phrase this in this way. And I've heard good feedback from that it kind of tones down the tension between them, and then they are better able to communicate. So I think there's a lot of things that we can do. I think we are always working to do those. I think there's just going to always be something new around the corner. So I think we just have to keep pedaling as fast as we can.
And if I may ask a follow-up question, do you feel empowered to make changes in your own courtroom it sounds like you do. I'm curious to know, I'm thinking about things like, this would be probably a big change, but integrated dockets and things that I've heard of, and I don't know how well they work, but do you feel generally like if you had an idea, you could move with it?
I think I could bring it to the powers that be. I don't think I could drastically change a docket. But I think that we have, Vermont, maybe it's not that unique. I just like to think it's unique, but we have incredible community resources. I know there's a group in Brattleboro that has been trying for a long time to get a family treatment court going. And again, it's going to impact a limited number of people, so it's really difficult to justify making that commitment of time and resources to do that. But I think that if we can try to just integrate those concepts and pull from those community resources to get some of them more involved in specific cases, we might be able to see those same results. So I don't think that I can drastically make changes, but I think that I can make small changes, incremental ones, and then hopefully be able to say, I've seen these positives happen. Can we do something more with that?
Thank you.
Thank you. Thank you very much for your opening remarks, and it's been nice to get to know you a little bit. I recently went to it was like a little seminar for chairs and vice chairs, and we talked a lot about in this little seminar relationships and how important they are in the work that we do. And I completely agree with that. But one of the points that I made was that sometimes it's a little upsetting when we can't pass good policy because we don't like someone. And I went up to the woman who was giving the seminar after, and I said, the idea of likability is different for women than it is for men, whether or not we want to admit it. It just is. It's just a different dynamic. And so the reason I'm bringing that up is because as I was looking at the scores, your management and temperament scores were lower than your actual overall judicial performance and integrity. And it was something that caught my eye. And so I couldn't help but wonder, but I appreciate that you reflect on these comments and that, it's something that you keep in mind as you do your work. And just wanted to say thank you and best of luck to you.
Thank you.
Hi, Judge Mann. It's nice to see you again. Senator Hewitt touched on one point I was going to make. As I was reading these, I was trying to figure out sort of how much of the comments may be gendered. I don't know if you remember, but I was one of the members of the Judicial Retention Committee the last time you were retained. And I was really, as you were talking and also beforehand, after I read your file, I was trying to remember back to 6 years ago and how much of the concerns that were brought up in these comments were concerns that were related then. I unfortunately cannot find my notes, but I do think there were some similar concerns back 6 years ago. And in fact, some of the things, literally some of the phrases you said in your opening remarks, I had total deja vu. And the comment about the suggestion box, you said 6 years ago, for example, and then the reflections on your drives and then a couple other things. And so I'm wondering if you could help me recall how much do you remember from 6 years ago and whether there are still the same kind of patterns in the comments or if things are different, and how much do you think has changed or stayed the same?
I think what I recall from that process was that there was it was a particular case that had gone on appeal, and I know who obviously had written the comment, and the comment was essentially like, this judge hates family court and should never be allowed to practice in family court. And I remember it was also a big flag of, okay, I know who wrote that because I really disliked being a divorce lawyer. I did it and I had to get out because it was really depressing. But from this perspective, it's totally different. And so I remember that aspect of it and saying, I actually really enjoy working in family court. I know a lot of people are like, oh God, don't put me in family division, but I enjoy the work. I enjoy the connection with the people that you're able to get and the hands-on. Beyond that, I remember not a lot of, certainly I don't remember anybody saying that I was unkind and mean. And I do wonder, I am sort of really rigid in terms of starting hearings on time. And if you've got a hearing block that is 9 to 10 o'clock, I have another hearing starting at 10 o'clock. And there are exceptions, right? I can look ahead and I can know that, oh, this 15-minute conference came off. We've got some wiggle room today. I can give the 9 o'clock hearing an extra 15 minutes and we'll be okay. But I work really diligently to make sure that we're using the time, that we're finishing it, and that we're also not encroaching on other people's time. It means a lot. I don't know, maybe it doesn't bother people as much, but I think that when attorneys have shown up, their clients have shown up, their witnesses have shown up, and we say, you know, we're gonna be running 45 minutes late, we're gonna be an hour late. I mean, I don't know, maybe it's just my mother, but I'm like, that's not okay. You don't tell people to show up and then just say, hey, you gotta hang out and wait for me. So I'm really, really diligent about that. And I have heard sometimes people speak on the WebEx when they can forget that it's an open mic and that I might be sitting there. And they
We're familiar
think,
with that.
yeah, you know, and it bothers them. So I don't know if some of that comes through in there.
Okay.
But I guess my overall take was I didn't read these and go, oh my God, everything that, you know, came through from the last process is a problem. And honestly, I did go back and pull the comments because I saved those.
Yeah,
Things.
I would assume you did.
And nothing stands out. Like when
Okay.
I read them, nothing jumped at me and said, "Ooh, I gotta fix this."
Okay, well, I want to name my own bias here, and nobody who knows me in this building would be surprised at this. And is that I have very low tolerance for how do I phrase this diplomatically? I have low tolerance for overly confident men who will you know, use their power in a way that is not what I think is appropriate. And so I guess what I would say is if I were reading these comments and you were a male judge, I would be really concerned. And that has actually been true in the past with judges that we've reviewed. So while I think you have explanations for all of them, and I also think that a lot of them are probably like, you are a strong and diligent woman, and that often rubs people the wrong way. Believe me, I know. And it does seem like there are some things you might need to work on. So my final question for you is, you said you reflected on these things on your drive home, and that's great. But I'm wondering if you need additional resources to help you maybe work through some of these challenges. And I know that these comments could be just a couple people saying it, so I don't want to overemphasize them, but they're concerning enough to me to read them to think, okay, maybe you might need some extra help to figure out how to deal with some of these things. And I'm wondering if you could reflect, is that, you know, training, is that a mentor, is that having somebody observe you in the courtroom, or you observe somebody else, so that you can maybe reflect a little bit more on where these comments might be coming from.
I think that I sort of assume this is most people would always welcome some kind of observation and feedback, whether that's coming from another judge or anything like that, because we do work in kind of a weird vacuum of lack of feedback, lack of just sort of perspective, right? And so whether it's effective or not, one thing that I regularly do, especially if I've had a hearing where I'm like, oh, you know, that was rough, I will go to the court reporter and say, did that trouble you? You know, because they're usually pretty honest. And sometimes I'm like, no, they're not giving me anything, you know, what can I do differently? You know, but they typically will say, oh no, it needed to happen. So that's where I'm struggling in terms of saying, I see these comments and I can appreciate where they're coming from, but I'm always open to anything.
Well, I wonder if you might reflect on that a little bit more and maybe come back to us with what you think might be helpful. Whether it's having another judge, you know, review your performance or something. Because I would really like to hear, after you think about it a little bit more, what would be helpful to you, because you clearly are an excellent judge and you clearly are doing really good, important work for the state. And it makes me sad that you're getting these comments. And so I would love to hear what you think could maybe help you, you know, be received better.
No, I definitely, I agree that feedback is really important.
Yeah.
And if we can, I think hearing it directly from the horse's mouth is really good. less optimistic about that. But I'd be happy any day of the week to have, another judge pop in and say, hey, there are some things you can do differently here. And if they say you could do this differently and, Judge Joe does it extremely well, I'm always happy for that because we don't get to see how each other runs a courtroom or those types of things. And I will say that recently, and actually before these comments came out, I had the unfortunate experience of attending Judge Durkin's funeral. And one of the comments was that, he started every hearing by saying, well, good morning, folks, how's everybody doing? And so I thought, that's not a bad thing to do. I often come in and I say, hello, or, try to be friendly. But I said, I'm gonna make more of an effort to do that because that's just genuinely, maybe it, breaks the ice, eases people's feelings. And so far, it doesn't work very well. You've got all these strange people that look at you like, what you want us to say, So if anybody's got techniques, I am all about it.
Yeah, well, I think it would be great for you to think about that and I would love to hear what you have to say. I mean, we have more opportunities to talk with you more. And so that would be helpful after you get a chance to think about it a little bit more.
Thank you.
All right, thanks so much, Your Honor. Probably like similar to Senator Collmore's comments there, it was, it's tough to get an estimation of somebody just by what's in this binder here. And, I look at the surveys from sort of the workers in the judiciary, and you strike me as someone I'd love to work with, I'm a labor guy. It seems like you're good and kind to people there. And it also strikes me as like, if I read these, I'd be a little bit nervous to come in the courtroom with you with the attorney comments, right? and I think it's perception and it's a limited response and it's not a back and forth, it's anonymous. But I think what might help me is if you can pick out maybe one of those comments or something somebody said, and you have a bit like, okay, I can see why they would think this, but is there anything you can just I know in my work here, I've been unkind, I've been impatient at times. And is there something that just strikes out yeah, you know what? That's accurate. I gotta fix that. I gotta work on it.
Well, I would say I can identify, I think, easily two things. One is I do tell people, you know what? I got this. I understand X, Y, Z. And I know that could rub people the wrong way, and I always worry when I do it. I think another thing is I definitely let them know when I am dissatisfied that they're coming in for a 1-hour hearing and they want to start piling on issues that we could have addressed easily because they're longstanding issues in the weeks, months leading up to this hearing. Because as I said, I know that when we start doing that, we're not going to reach a final conclusion for that hearing. So I do let them know that. So I am sure that that is definitely a component of that. Well, she wants to, be upset that we're doing this, but this is what we want to do. So there is that, not necessarily, I don't want to say I'm losing the right word there, but definitely a difference of approach. I do try in the bench bars early on to let people know these are my expectations, right? And that's why we're going to have a pretrial conference. That's why when we have the pretrial conference, I try to say, this is what we're doing. But yeah, I get it. I am sure that does not read well because I am letting them know that it's not okay. So please don't do this next time. So that I can definitely see feeding into some of those comments. And if you don't do that, I'm not really sure. I haven't come up with another way to do that. It's not like I'm going to sanction somebody for filing a motion that's a legitimate motion or trying to address an issue. But just, plan ahead a little more. Make sure we're maximizing the time so that your clients are getting where they need to go. And that we're using our time, especially because there's never enough time.
Thank you.
Thank you.
Any follow-ups? Great. Well, thank you so much, Judge. Thank you for your time. And we will move to the Honorable Megan Shaffritz. I like calling people honorable, so I'll keep saying it because
We appreciate that. One of my
I find it delightful.
husband's friends put that in his phone for my contact. I feel like embarrassed. Yeah.
I say just own
Appreciate
it.
that.
Yes.
Well, good evening, everyone, Chair Arsenault and members of the Joint Committee. So my name is Megan Shaffritz, and I am now in my 7th year as a Vermont Superior Court Judge. This is my 2nd time through the rotation process, although the first time I had only been a judge for like 8 or 9 months. So everything was still brand new to me. This is a bit of a different experience, but really, really welcome. And I'll continue on a theme. I do also want to start by thanking the committee for its very valuable work and the time and attention that you devote to this important issue of judicial retention. As you heard, my colleagues and I actually have very few chances to receive frank and honest feedback from attorneys and from the staff, the attorneys that appear before us and the staff that we work with. And yet the value of those comments, both positive and negative, cannot be overstated. It helps us to see administration of justice through the eyes of the participants, which in turn allows us to grow and be better at our jobs. It helps us work to improve the quality of justice that we provide to Vermonters. And so I really appreciate the legislature providing us this opportunity. My career as a judge so far has been incredibly demanding and challenging and stressful at times, sometimes even, I would say, exhausting, but also at the same time so interesting and exciting and diverse and fun and rewarding. I've been lucky enough to sit in all 3 of the Superior Court divisions within my jurisdiction, so civil and criminal and family. However, the bulk of my experience has been in the family and the civil rights. One of the most difficult things I think about being a judge is that we typically encounter people on their worst days. There are some happy events that bring people to court, but I would say that's not the majority. Most often, the people who appear before us are under great stress or facing the most difficult personal situations. So for example, during my rotation in the Rutland Civil Division, I listened to people who were at risk of not having anywhere to live because they faced losing their homes to eviction actions or mortgage foreclosures. I heard cases where Vermonters were seeking redress because they or their loved ones had been seriously injured by the negligence or wrongful acts of others. I decided collections cases brought against people who had accumulated credit card or other debt beyond their resources, and cases brought by people who were seeking court orders to protect them from threats or other stalking behavior that they were experiencing. During my rotations in the Chittenden Family Division, I heard cases involving similarly difficult, deeply personal, and sometimes heartbreaking circumstances. There were domestic violence victims who were seeking an order of protection against their abuser. Parents who, due to their own struggles, were unable to properly care for their children and may have had those children removed from the home. And now they are at risk of having their parental rights terminated. I preside over actions filed against minors and young adults who are accused of committing a delinquent offense, sometimes a rather small infraction, but other times with grave and even fatal consequences. The court must provide space and opportunity to acknowledge and redress the harm to the victim and the community in those situations, while also recognizing that the brains of these young people are not yet fully developed, and that they also must have the opportunity to learn and grow from the experience and feel consequences due to their actions, but in a way that does not negatively impact their entire future. I also listen to cases about patients with mental illness who present risk of harm to themselves or others and need treatment or medication that they are unwilling or unable to consent to. Or about partners whose relationship is dissolving and they are unable to agree on what is best for their children or how to equitably divide their possessions and debts and provide for their separate futures. Something else that adds to the further to the challenges of the job of being a judge is that the parties that are involved in the legal system are so often struggling with issues like addiction and substance abuse, mental illness, poverty, homelessness, intimate partner violence, other trauma that may be at the root of their legal problems, and it makes it that much harder for them to successfully deal with them. Through my work on the bench, I have found that there simply are not enough resources available to help these folks get their lives back on track, which in turn then would help them in resolving their court cases. So every day I work extremely hard to treat all of these cases and the persons that appear before me with compassion and empathy to ensure procedural fairness in my hearings while still correctly and fairly applying the law. Sometimes that means telling people things they don't want to hear, or due to the necessary limitations of the day, not having enough time to hear everything that people want to tell you, what they would like you to know about their situation. There's simply just not enough hearing time in our schedules or overall judicial resources to meet every litigant's demands. And I always feel very sorry when I have to cut someone or some proceeding short. This is particularly true given all the duties and daily obligations that we have off the bench, which include reading and writing and research, all of that is required to prepare our weekly dockets, issuing written decisions that are clearly reasoned and easy to understand, especially for self-represented litigants, reviewing the filings and ruling on motions and other matters that come to us in our task queues, interacting with court staff and other administrative duties, sitting on committees, attending trainings, conducting informational sessions for lawyers and members of the public. These are all things that we need to do in the time that we're not on the bench, which frankly, in family docket, I'm on the bench basically every day from 8:30 to 4. Let me say another word about sitting in the domestic docket. I know the committee received a written comment today, I think a few hours ago maybe, from a litigant who was dissatisfied with the decision I made in a case, but more importantly with the court process. I had just a brief chance to review these comments, and of course it was very hard to read. But I think the writer's comments show why family court is really hard. In my view, it's the most difficult docket to sit in. There is nothing more personal than the decisions that we make about a person's family, about their rights to make choices for their children, and how much time and contact they're going to have with their children. And so every decision about custody or divorce involves really a losing party, especially when parents are not getting along and the tension in their relationship and the case is really high. Someone is left feeling aggrieved by the court's decision. They are left feeling that the court did not listen or did not understand. And every decision in those type of cases forces the court to make choices, often in close cases, sometimes between two very deserving parents. And it is very hard to find a resolution where both sides feel that justice has been served. Most of the time, absent a stipulation, both parents cannot get what they want. Under Vermont law, the court cannot award parents shared legal rights and responsibilities. That is, that shared decision-making for major decisions about the children, unless the parents agree. So under Vermont law, we can't force parents who don't get along to make joint decisions for their children. So the court must make a decision for one parent or the other. And we do that by listening to the evidence, the testimony of witnesses, reviewing documents that have been admitted into evidence, making findings of fact, and analyzing and applying the statutory best interest factors that are set forth by the legislature. Now, clearly, this commenter disagreed with the conclusions I reached, but I really feel terrible that the litigant had this experience in my courtroom. I do not like knowing that he was so upset by the decision of the court. I'm always looking for ways to improve my process, and I'm sure in this case I could have done a better job, perhaps by explaining my decision or letting him know that I heard his concerns, or addressing his arguments and articulating why I did not find them persuasive or why I chose to apply the factors in a different way. I will note that the decision that was issued, it was issued during my first full rotation as a judge. And with every case, I try to get better. I try to improve my skills and improve the way I run my courtroom. And I believe that actually the comments from my surveys this time around overwhelmingly show that I've had some success in achieving those goals. I've gotten better. The comments from the attorneys and the staff over the past 3 years talk about my qualities of fairness and compassion and empathy and impartiality and my ability to make all parties feel heard and be respectful of all parties. And these are all qualities that are really important to me, and I really work hard on being able to achieve those. And I am grateful that a lot of the folks who filled out these surveys took the time to make those comments and feel that I am making some progress in that area and am able to achieve a fair and impartial process that lets everybody be heard. And in fact, I think there was a comment that said, I don't always agree with the decisions that Judge Shafritz makes, but I respect how she does them, and I feel that they're well reasoned and she reaches them in an impartial way, and that was very meaningful to me. And so while I really deeply regret that a litigant had this experience in my courtroom and came away, albeit 5.5 years ago, but came away with this impression that I didn't care or that I made the wrong decision or that the process wasn't fair, I do not feel that that represents who I am now as a judge. In fact, in September of 2023, I was reassigned back to the Chittenden Family Division. And I know some of my colleagues have mentioned that sitting in Chittenden County is truly different from everywhere else. That's truly the case, given the size and the caseload and the number of judges and the number of court staff we have. We frequently like to joke that trying to make changes in Chittenden is like trying to steer the Titanic. It's basically really slow and maybe a doomed process. But however, at this stage, back in September 23, we had a really actually unique opportunity, an exciting opportunity to step up and provide some input and guidance into docket management, which you are not always able to do in a court of that size. And so the situation was that the longtime clerk was winding down towards retirement, and there had been a significant turnover in the staff. So there was an opportunity for leadership to help steer things in the right direction. And so with the blessing of the chief superior judge and trial court operations, I invested a lot of my time thinking about scheduling and distribution of dockets, judicial duties, and how we can improve our efficiency. And I worked closely with staff regarding the timely processing of judges' orders and how to move and close cases, making sure that we were able to administer justice in the most fair and timely way. And this task was really made even more difficult because for essentially the entire time, we've been short-staffed due to the judicial vacancies and staff turnover. So we were down one judge in both the family and the criminal division. So we had 2 judges doing the work of what would normally be done by 3 judges. And it also brought numerous new JAs on board, but they were brand new and still learning. At this point, 18 months or so later, we've made a lot of improvements. I'm really proud to report that we've raised our clearance rates. I know you heard a little bit about this maybe last hearing, but there were numbers that were just released last week. And so in April of 2024, we were at a clearance rate of 61% in the family division, which is really, it's not that good. But in January 2025, we hit 113%.
Wow.
So 100%, as you probably know, means you're closing as many cases as you open. But when you go over 100, so 113%, we're reducing our backlog. We're closing more cases than are filed. We are moving cases along, and we're heading in the right direction. And I'm really proud of that and the work that it took to get there. So all of this progress comes just in time for me to transition to a new role, which I wanted not to forget to mention to you. But so with the appointment of our newest colleagues, you may know there were 4 new judges appointed recently. 2 of those folks have been assigned to Chittenden Family Division. And so as of last week, I've been reassigned to the newly created Northwest Float position. And in that role, I'll provide additional coverage to the Chittenden Civil and the Franklin Family docket. So I'm still in kind of my main areas of expertise but in Chittenden Civil and Franklin Family, I'm really excited to bring my skills and experience to both of those areas. I'll wrap up because I know I don't want to use up all of your time, but I will say it's somewhat of a surprise to me that at this stage of the career, I find myself on the more senior end of the experience spectrum in terms of trial court judges. We've had a lot of retirements and so I wouldn't think that being a judge for 7 years would kind of put you more senior, but I did the math, and out of the 36 or so superior judges, as of next rotation, only 13 are more senior than me. So I do feel I'm in that next category, but it's along with my colleagues who are here. This is a role that I'm looking forward to and I really enjoy. And for example, I've spent a lot of time over the past few weeks working and training my new colleagues who are coming in to the family court. I hope to give them the benefit of some of my experience, the things I've learned over the past 7 years so that they can continue the substantial progress we've made in the family court docket. This loss of the seniority, the wisdom, the institutional experience of experienced judges, I think is unfortunate for the judiciary. But on the other hand, it also strengthens my commitment to this public service. I have to say, I truly love my job as being a judge. And so I really hope to have the opportunity to continue to make a difference in my community, serve the state of Vermont in this role for me. And I look forward to our discussion and answering any questions. Thank you.
Thank you so much. Before we move to questions, I just want to say thank you for addressing a rather emergent comment. I'll just say, like, you know, there was discussion this morning about whether it was even fair to for any of us to bring it up because it was just received by us this morning and by you this afternoon, or maybe even like late afternoon. So I just wanted to say thank you for that. And for anyone listening, to remind folks that there is a public hearing portion of this process that will be on Wednesday, February 26th, here at the State House. I believe it's at 5 p.m. And that is a great place for folks to add additional comments in sort of our regular flow. So thank you for taking in and commenting. And shall we start on this one, Casey?
Thanks so much, Your Honor. And I really enjoyed hearing from you. And I feel very comfortable with your competency in the courtroom from what I've heard and read. I'd like to get more into the motivations, maybe, because you've listed some like grisly cases that you've overseen, some with children, people like unhoused. And so I'd love if you could, you touched on it at the end, but I'd love if you could maybe just talk about it a little more. What brings you joy about this job, that you get up every day to do it? And what do you take home with you? And how much does that weigh on you? But I'd love just a little more insight into it that way.
Yes, no, thank you. I mean, at the end, it all weighs on you. I mean, the decisions we have to make are the most difficult and important decisions. And in the dockets that we have, they can have lifelong impact. I mean, if you make a decision about someone's children or terminating, a parent's rights, those have lifelong impacts. So those do follow you home. But I also, and I didn't maybe touch upon in the opening remarks, although I think maybe in my letter, there are so many positive aspects about the job and opportunities to make a positive connection or a difference with the parties in front of you to recognize, for example, in the delinquency cases where I have children committed offenses, I actually really enjoy sitting on those cases because they often move fairly promptly and I can see them from beginning to end. It's the goal of the juvenile justice system to move those cases along so that there are prompt consequences, especially for these, younger kids who forget what happened 2 weeks ago, and so commend them for the progress they've made or for taking responsibility for their actions. And so making that positive connection and being able to give them some praise, which they may not hear a lot, from others in their life. As a judge, as a person of importance in that role, I can do that for them. And the same thing with parents who Judge Mann mentioned it as well, but I always try to note something positive where they've reached some agreement. I commend them for that, whether with attorneys or the self-represented folks, and tell them that this bodes really well for their future because they have been able to come to agreement. They both have the best interest of their children in mind, and they are going to be doing this going forward for, it doesn't even end when the child turns 18. And they are really in a good spot because they have been able to reach some agreements. They don't agree on everything, but they've got kind of that roadmap, that blueprint for going forward. So, and before I joined the bench, I worked for the state of Vermont, the Attorney General's office, and I had always wanted a career in public service. And being able to, I believe so deeply in our system of justice, our legal system, wanting it to be the best it can be, and that's sort of where I found my calling. So every day I have to help try to make that better. I get to help try to administer justice for Vermonters, and I take a lot of joy find that rewarding to be a part of the process and be the best I can every day, which I know that I always could have done something better, but that's sort of what drives me in terms of why I can say that I love my job, even though there are a lot of difficult challenges to it.
That's great. Thanks very much.
Thank you.
Hi, Judge Shaffritz. It's nice to see you.
Good to see you again.
I know we're all sort of trying to take the comments with the weight that they deserve, but there was a really interesting comment for you that I haven't seen for any judge in my too many years of doing this, which is that Judge Staffritz is exceptionally good at talking to litigants with mental disabilities and being considerate of setting up a courtroom that slows down to allow their participation. And I thought that was really impressive and something I hadn't actually considered. And I'm wondering, and I also have never seen it listed as something that you all get training in. And you get training in lots of different types of courtroom management, almost a classroom management, courtroom management. But I've never seen a training for how to accommodate and help people with mental disabilities be able to access justice. And I wonder if you could talk about that a little bit more.
Sure. Well, I really appreciated that comment because again, it is all about access to justice, and we have to be accommodating and recognize there are people with mental disabilities. And so I do try to, if I know about that, if I have those folks, to make sure that that they get an opportunity to speak, if that's appropriate, that would slow the process down, that I make sure I repeat things or I'm very clear, or I give them more time to speak with their attorney if they need it. I think at the last hearing, someone else also mentioned the communication specialists that the judiciary folks can have access to, which can help folks if they need extra time for processing or they need help expressing themselves, that is available. They can ask for that ahead of time, and we approve that. And I'm trying to think of a specific training that we actually received, and I think that within all of the Judicial College sessions and all of the trainings that we have, that it must have been covered as a topic, but it is certainly very important. And I think it's maybe something that I just pay attention to and try to understand, what does each individual person litigants need from me? And can I do that? But you can't always completely slow down a process, taking 6 hours for a hearing where you've only got one or something. I mean, it's rationing to some extent, but I try to understand what can I do for this person to make sure they understand the court process and what I'm doing in my role and their role. And so it's just being aware of that. And I will say, my daughter's dyslexic, and I watched her through struggles of reading and how that affected her. And I think I always think about that in terms of, it's not something you know from looking at her, but does this person have a disability or a limitation that I need to try to be aware of?
Yeah, that's really great. And Judge Zelny was making some movements but there might be still. No, there might be.
You don't remember the training that we
did. But what I was gonna say is maybe you should give that training, and I think that there are organizations that, are advocates for disability rights groups, et cetera. Maybe that's a great addition, because I think
we should do it.
people with mental disabilities or developmental disabilities really should be able to have access to their day in court if they need it and to have the accommodations necessary. So that's great. Thanks.
Thank you. I appreciate that.
I too just want to take a moment to give you some kudos. This comment I really enjoyed. I will confess that I did not particularly care for this judge when she started, but she's grown into the job and has become a solid performer. I vote to keep her around.
That's the one about me being too Boston.
Yes, I love that. But no, I think, we can all hope to improve in our lifetimes, and that just kind of really warmed my heart, and congratulations, that's an achievement.
I appreciate that. Thank you.
So I have a couple things. So I really appreciated in your, it's in your answer to a question about the court's electronic filing and case management system. And you gave probably, I think, one of the longer responses that I've seen. And I really appreciated the level of detail that you mentioned. And these, seemingly, I often think about the things around my house that I've been meaning to get fixed, and then they just become part of the house, and like I don't see them anymore. And someone walking in would be like, why is that like that? And that's what I thought when you mentioned, the mess of devices and wires, hookups for at least 2 monitors, difficult to, and the way that you thought about actually our monitors are situated such that sometimes we have to turn away from parties and witnesses and things. I just think that demonstrates a level of attention to detail and, self-awareness, spatial awareness, things that I probably wouldn't have put on my list of like top 5 judicial temperament need something, but I think I appreciate it. And there were a couple other I have all kinds of notes here, but there was, and I don't usually go to the comments for my question, but this one really struck me. I thought you were going to take this one, Senator Hardy.
Left it for you.
On page 18, I don't know if you have it in front of you, the first response from full written response from the court staff, assistant judges, and non-attorneys is a long response about something that I think in some ways has very little to do with you, from what I can tell. But it does paint quite a picture. So I just wanted to just read this part to you and ask you to comment. So the author of the comment says, "What I am criticizing is her unwillingness to assert her role as the presiding family division judge to say no to the directives that are having a very negative impact on the litigants and the people that we serve." I was wondering if you know what that is in reference to, and if you have any thoughts.
I do, thank you for that, for the question, and I was really struck to receive, to read, the comment as well, because it is so specific. I think, have an idea of what it refers to, and I think it maybe arises out of maybe a misunderstanding of what my abilities or my role. But so first, let me say there was, it involves a time when the court administrator's office and trial court operations, and I think with the chief superior judge, made a change in procedure and protocols of how certain cases were managed or handled by the staff. And it actually was something that Chittenden wasn't doing the way the rest of the counties were, and they wanted to standardize it. And so I did give input to those folks that I thought the way we were doing things was working well, and it impacted some of the tasks that this person had. So it changed her role, and I don't think she felt good about that. But in the end, my feeling was it was really above my pay grade. It wasn't something that I had control over. But what I really regret is I've worked with this person for a long time, and I really worked very hard to cultivate strong connections, good working relationship with the staff. And I do feel that actually the comments reflect that. But I'm sorry that if she felt that I wasn't being supportive enough or wasn't understanding what she wanted or how this impacted her. Maybe I could have done better in addressing her concerns or hearing her position. Even if I couldn't ultimately fix it or do anything about it, I could have done a better job of understanding where she was coming from and how she received kind of what was happening. And so that's what I really took away from that. And I wish that I had done a better job at that time of connecting with her about it.
Gotcha. Thank you.
Thank you.
Hello, Judge, how are you?
Good evening. Good thing.
So as is true with all four of the judges appearing tonight and the four from last week, the overwhelming responses, and I'm one that does read the comments as opposed to, because I'm not a lawyer and I don't pretend to be one, overwhelmingly positive. So sometimes I feel like we're not doing our job if we don't find something in here to ask about that's negative. And I feel at times like I'm the skunk at the garden party, to be fair. Nonetheless, there is a reference in one of them that talks about a case that lasted for a year, and whoever it was that came in after, it got resolved quickly, I guess, to their satisfaction. And I didn't know if that was just sort of a lucky break that whoever came in after, or was it a court vacancy? But talk a little bit, if you would, about that case.
I noted that comment, and unfortunately, I am at a loss to explain it, but I will say, because the case should not sit for a year with nothing happening, and absolutely, if that happened, the commenter absolutely right to raise it. I can't think of a time when that happened, and so maybe again, there was a perception. I have mentioned that we were short-staffed, and so there were times when two of us judges were just struggling to keep our heads above water with all the cases and all the tasks, and it's possible that something fell through, but I wish I knew. I wish I had more information so that I could reflect on what else I could have done to move that along. But I agree that, if a case sat for over a year, that is not the timely administration of justice that we want to have. And so I don't know when this happened. I don't know what court. But I wish I did, because that's the type of constructive criticism or feedback that I would want to have so I can do better.
Thank you.
Yeah, thank you.
There.
Hi.
I actually had the same thing underlined that Representative Arsenal had just mentioned to you or asked you about. So I guess I don't have any other questions other than, you have such a lot of good feedback, and as hard as it is to I'm sure read some of the somewhat negative ones. Fair, firm, and wicked smart is a pretty nice comment.
I thought of blowing that up. I appreciated that, and the people that take the time to make these surveys.
Yeah.
I'm just so grateful for that, positive and negative. Of course, it's nice to, people take the time to say something positive, but the negative ones are things we want to hear, so that we can take note of them and try to do better. So I appreciate it.
Thank you.
Hello, Your Honor. Poor people have stole my thunder.
That's why we go around one way and then we go around the
But I'm gonna expand upon it just a little bit.
Sure.
I highlight good comments, and then I highlight other pieces of them, and I will confess I did not particularly care for this judge when she started, and then it ends with, I vote to keep her around. That kind of tells me maybe it would have been nice to see a timeline of when this person had their interaction with you. It's been 7 years or 6 years with your retention, and maybe that was in the beginning when you were starting to get your feet. And I imagine it's like drinking from several fire hoses, and then COVID hits and flips the whole thing over, and you do it all over again. And then the wicked smart thing just made me laugh. It really did. And the one thing I take away from that is it shows personality in the courtroom, that that people are taking to you and like what you're doing in there, and I appreciate that. But am I correct when I'm asking about this question? Maybe it was a while ago, or this
It
feedback?
could have been, I would hope so. But again, that just goes to the fact that we, every day, and this is something that, many judges, I think, cite as a positive thing about the job. Every day is a day to learn something new, both, you know, an area of the law or a legal aspect, but also, you know, procedural or to, about ourselves or about the process that we can use to improve. And I would hope, I think that the comment exactly captured what we hope the process is, that we are constantly improving and that I was able to demonstrate that at least to this person. I'm very, very glad for it. Thank you. Sorry, you're on.
So my thunder's been stolen too, but I'm gonna go back to the letter that we all got today.
Yes.
And you did read it.
Yeah,
And I'm gonna read an excerpt from it, and then I have a question.
sure.
And there's a little story that goes along with it. So it said, my ex-wife was arrested twice, domestic assault and violation of conditions of release during our divorce, claimed no contest, attended court diversion, completed the probation, and this judge gave her sole legal custody, claiming she was more legally responsible parent that can foster a positive working relationship between all. I've had two of my constituents this term alone that have come to me and asked me to craft a bill for them. And all three of them were mothers. All three of their sons had gone through divorces. And I said, well, you know, what do you want me to, you know, what do you want the bill to look like? I said, well, I think they don't know each other. They all think that females in Vermont get all the breaks in a divorce. And one of them, the case was that the ex-wife was actually had filed for divorce, got custody of the kids, and was moving to a different state. Can you tell me what I should tell those people? I didn't craft the bill because I haven't had a chance to, but I've got to sit down with Eric Fitzpatrick and come up with something that is very handy. Do you feel that women have an advantage in the courts?
I'm not quite sure what the bill would say, but obviously that's your purview and not mine. All I can say to that is that every judge I know works hard every day to judge each case on its merits, on the people that appear in front of them, and on the facts. And absolutely not based on the gender of the party. I think that shows actually in my comments where folks were asked, did I have a preference for men or, you know, women? And I think I got excellence as to having no bias. So we know that is not appropriate, not fair. And so it is something that every judge strives for in terms of having fair and impartial process. We have been trained on implicit bias in terms of you know, how to combat that, how to recognize that. So of course somebody would say, no, I don't favor, you know, mothers over fathers. But knowing that everybody has implicit bias and how we address that and deal with that. So all I can say is for myself and all of my colleagues that I believe that's something that happens. But I mean, in this case, what I take away or I think is so more important is not the specific facts of the case, but the fact that this was this person's experience, and that I just feel terrible about because he feels that what he took from the process was that it wasn't fair. And that I didn't give him a fair hearing or something like that. And that is really hits me because that is the last thing that you want for a hearing. People may not agree with your decisions, and if they don't agree, they have a right to take an appeal from that decision. But the process needs to be fair, and they need to feel that you were impartial and judged every case on its merits. And he obviously did not feel that way, did not take that away, and I wish I could go back and do something different so that he had a different experience with the process, even if the outcome is the same, that he had a different experience with the process, because his views here don't help him, they don't help anyone, they don't help these two parents co-parent these kids, they don't help them have a productive relationship so that the children can be comfortable with both parents. And so this is his whole view of, I think, not just me, but the family court system. And that is not going to help him in the future or help him feel that any decision that's made is fair. Thank you for asking.
Thank you so
I
much.
appreciate it.
Thank you.
Thank you.
Time. And we'll now invite Honorable Timothy Tomasi. And I have a prelude, a preamble before you speak. I just want to make a couple of things very clear for our committee, and for you and for everyone, really. So first, just to address one of the responses that we received, specifically, yeah, so I'm gonna read something. That's why I have my computer. Sorry, this was the battle I lost with the printer earlier, could not print this out. So I just want to let everyone know that tonight the committee is facing an unusual issue with respect to the survey responses received for Judge Tomasi. This is because one of the attorneys who responded made critical comments about Judge Tomasi's performance in a case that is still pending in the probate division and could come before Judge Tomasi again on appeal to the civil division. During retention proceedings, it is not unusual for a judge to respond to comments with respect to a case that is fully completed. However, because the comments by this attorney were made about a case that is still pending, the committee recognizes that the Vermont Code of Judicial Conduct places strict limits on what Judge Tomasi can say. Rule 2.10A of the code specifically provides that, quote, "A judge shall not make any public statement that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in any court," end quote. As is explained in the comments to the rule, these, quote, "restrictions on judicial speech are essential to the maintenance of the independence, integrity, and impartiality of the judiciary," close quote. In addition, any comments that a judge makes about a pending case could be viewed as expressing the judge's views about the case and what its outcome should be. For these reasons, the committee understands that Rule 2.10A prevents Judge Tomasi from speaking about the case that was the subject of the particular attorney's comments in the survey. There is an exception in Rule 2.10D to the prohibition on making public comments on pending cases that allows a judge to make public statements to, quote, "explain court procedures," end quote. On this basis, Judge Tomasi could choose to comment in general on things relevant to this complaint, such as how a probate case might come before a superior court judge sitting in the criminal division, and what types of decisions could be involved in that process. However, the committee recognizes that whether to comment in this way is a matter of discretion for Judge Tomasi, and that he could reasonably conclude that it would be impossible for him to do so without risking an unintentional violation of the rule's requirement that he make no public statement that might impair the fairness of a pending case. So with that said, I will also share that we are aware of the existence of a document that I think you participated in voluntarily, that was produced produced out a product of the last retention process. And we are not going to raise issues related to that letter in open meeting unless you first bring up elements of, I don't know if I should, that document, I don't know if it's a letter, but well, that document, if you elect on your own to bring anything up in open meeting, we can ask specific questions related to precisely what you raise. All other matters any questions that committee members may have about the contents of that document would be discussed in executive session. Okay. Everyone good?
Mhm.
Okay, thank you for your patience. Floor is yours.
Thank you. Chair Arsenal, Vice Chair Elmer, and members of the committee, thank you for the opportunity to meet with you tonight, discuss my experience as a judge. I'm honored to be here. Let me first thank you all for volunteering extra duties from your regular legislative load to be part of this important committee. You know, it's an option, so I appreciate you doing that. Also want to thank you as members of the legislature for your support and the legislature's support for very many issues on the judiciary as a whole for the last 3 years, including important slots for new staff and judges to help address the COVID backlogs, new IT initiatives, courthouse construction, funding for translation services and communication specialists so people can understand the cases that are really happening and involving them, and courthouse security funding that really kept litigants safe, staff safe, and us safer as well. So that kind of support is really important, I think, to keep our mission to provide an effective system of justice going for Vermont. As I mentioned in my supporting statement, my grandparents immigrated from Italy and settled in Montpelier. I was born here. I lived in New York City and Boston and New Hampshire, but Vermont's always been home. I got some private sector experience, but really my life as a profession has been devoted to public service at the Attorney General's office as a federal appellate law clerk and at the U.S. Attorney's office in Vermont. And it's now been my great honor for the last 14 years plus to be a judge, a Superior Court judge in Vermont, which I really think is one of the highest forms of public service for which an attorney can aspire. Depending upon whether you include our fearless leader, Judge Zone, in the calculation, I'm either second or third now in seniority. I looked at some photos of my swearing in the other day and I missed my brown hair. 6 months into this job, it's gone. But I am grateful at this stage to have the institutional experience and knowledge passed down to the next generation of selected locals that we have. Back in the medical program, and I'm proud to say that Judge Corbett, we saw last week, is on that team. The last 6 years have seen an incredible number of changes to the state and the judiciary. Of course, we went through the COVID-19 pandemic and the horrible floods. The judiciary transitioned to an all-electronic filing system and case management system, implemented fully remote capabilities in every courtroom across the state, and moved to a self-contained computer system. Any one of those things would be a pretty big deal, but taken together, it's pretty seismic change from what happened 6 years ago. I'm currently assigned to the Civil Division in Washington County, it's down the road, which has a significant number of larger cases. It tends to be the place where people sue the state, or groups sue the state, or the state sues entities or corporations from out of state. As part of that assignment, I also cover the mental health docket in the family court. And most of you know, following the July 2023 floods, the probate division and civil division were actually had to vacate our courthouse on State Street. Luckily, we were able to move into the Prairie Courthouse, where we were there until I think mid-April of 2024. It was a difficult and trying time. Keep cases and hearings going in a timely manner with 5 judges using 3 courtrooms, one of which was fairly small. Additionally, the civil division had one assistant, judicial assistant who was out on leave the whole time, and another one left in January, which meant that our court operations manager, Donna Waters, had to really cover not only her own job, but that work of 2 others. And it's really exemplary, and she's a dedicated and selfless public servant who has been able to keep us afloat. I really appreciate the excellent work excellent work of all the staff who worked hard under those cramped circumstances to keep things on track. While we may not have been at peak efficiency during that period, I believe we functioned admirably in very difficult circumstances, mostly due to the staff's efforts. During the last term of service, I also sat in the family division in Washington County for a year, and all divisions in Orange County, and the criminal division of Caledonia County, and the criminal division of Windsor County, which also gave me the chance to sit in the treatment court that Judge Mann mentioned a minute ago, and that Judge Griffin spoke of so much last week, and his enthusiasm is infectious, of course. But let me just take a brief moment then just to add my voice to his, to encourage you, if you can, to go to a treatment court, especially at graduation. They are always moving experiences. You know, it's important, I think, to think about treatment courts. It's not just benefiting the people who the defendants and the families themselves. I think you have to think about the people who otherwise might have been negatively impacted had that person continued with their addiction. The person who they would have used drugs with in the future, who that person would become addicted. The victims of future assaults, robberies, and burglaries, who that person might have committed to fund their addiction. Persons who might have been victims of drunk drivers or inebriated drivers, which didn't happen because we intervened in that time. And then the cost of the savings in the judicial system, the healthcare system, not having closed cases from that person, not having overdose cases or hepatitis cases from that person, and really the benefits to the community as a whole from having someone who's holding down a job, who's maybe having children and spending money downtown and paying taxes. So you think about, oftentimes people talk about win-win things, but there's too many wins to count with treatment courts. So I certainly hope we find an ability to keep them going in the future. In addition to my sort of daily duties, I also volunteered to do other things on behalf of the judiciary. I've sat as a substitute justice at the Supreme Court numerous times. I'm the chair of the Criminal Oversight Committee and the Committee on Public Access to Court Records Committee. I'm a member of the Supreme Court's advisory group on remote court proceedings. And I'm the judiciary representative on the board of managers of the Vermont Bar Association. I welcome and appreciate the process that we're engaging in here through this process. I know all judges, including me, welcome this process and want to improve, want to do what is necessary to address concerns people may have or perception people may have about the important work that we do. I think the retention process at its best really can help us both identify potential areas of concerns at an early point, raise the judge's consciousness about those issues, and suggest ways that he or she might be able to address those going forward. And it's really just useful for us all to take a time to take a pause in what we do to reflect on what's been going on in our performances and make improvements where needed. As for me, the last comment, the last retention cycle that we had, I know that Senator Hardy was here with us then. So there were definitely a few comments raising concerns about my demeanor. So I reflected on those, and I told the committee back then that I would work hard to improve in that area, to obtain additional trainings and engage in judicial observations, both by me and by me. And I've done all of those things. Additionally, I've taken or continued to take a number of steps over the last 6 years to try to get input from other various sources on my performance, and also to engage in sort of ongoing self-evaluation. Specifically, I continue to have brown bags with attorneys where I sought their input on court process and on my performance, and I told them if they didn't want to share that publicly, they could do it anonymously through our court operations managers. I often meet with attorneys after jury trials to share my thoughts on their performances and ask them to give me feedback on how I've done that in kind of chambers meeting. I ask for feedback and impressions from court staff and court officers who often see me, every day. Have a long breadth of experience. Sometimes after difficult hearings, I ask them how they think went, so that something can be done different to improve upon what has happened. Following up on a suggestion from Senator Bennion last time, actually, he recommended that maybe I should try to take recordings of myself. So I've gone back and reviewed videos and audio recordings of myself to sort of get a sense of maybe how my interactions were and how my demeanor was coming across in that way. I did engage in the VBA midterm reviews, which I think is a really important addition to our process of having something instead of once every 6 years to get some feedback from attorneys. When I have been stationed in other courthouses, I found it really useful to try to, when I can, observe other judges. Judge Mann was, when I was with her for a couple of years and observed her, I didn't see her being unkind ever, just for the most part. And you can learn a lot from other judges, and we all do things that maybe because we saw somebody do it once, that's how we do it. But there's a lot of ways we can learn by observing other judges, and I still try to do that whenever we can. I mentioned in my last retention cycle that I was hopeful that maybe we could develop a program where retired judges could come back and give us feedback. I'm happy to say that with Judge Zone's leadership and leadership of others, we now have that program that's recently become in place. I know following my last retention, I did have a seasoned judge come and observe me, and I appreciated that and appreciated his comments, and I think it's going to be a useful thing to help us all do our job better. I appreciate very much also the survey results and the comments regarding my performance. I work diligently to be prepared for every hearing, to explain the process to litigants, ask the necessary questions, maintain appropriate demeanor, and to give each side a chance to fully make their points and to issue rulings that are right on the law and the facts. I'm appreciative of the numerous comments, commending my preparedness, skills as a jurist, and overall judicial performance. I appreciate also the robust numbers of attorneys involved. Give the responses, I think 80 attorneys responded for me. I'm not sure I understand the weighted averages right, but I'm 75% sure I do. And if I am right, then I am ranked between very good and excellent across all categories. But I'm really especially appreciative of the 100% of the staff and poll who recommended that I be retained. Our staff do an incredible job, not only sort of keeping 6 balls in the air and juggling all the different tasks and filings that come in and motions and orders, but really being the face of the judiciary to folks who are coming in, whether on the phone or at the window, folks who don't necessarily know what the process is and who may be very upset and probably being on their best behavior. And really try to go out of my way to thank staff at gatherings for their civility, their professionalism, and their patience for dealing with those folks. And I've not seen them ever snap at anyone who's going through those difficult times. I do acknowledge, though, however, there were a couple of negative comments that went along with the vast majority of positive ones. I think the same one said I might be in favor of tenants here and there and in favor of the state as opposed to individuals. I'm happy to say that it doesn't look from the other survey results if that's any kind of a pattern. I'm sorry to read such comments because I do work very hard to try to make my decisions based on facts and the law as presented. And interestingly, 2 of the opinions I happened to provide you were actually cases where I ruled in favor of the individual against the state. But nonetheless, I really tried to reflect on those comments and how anything I might have said or done may have given someone the impression of favor. I'm certainly going to double down and redouble my efforts in those regards to make sure that no one feels that there's any favor of my decisions. I mentioned in my written submissions in conclusion, really, that I believe the court has to be a place where people can speak freely and be understood and feel safe and can have confidence that they're going to receive impartial justice. I try to make that happen every day that I'm on the bench. I think my anonymous comments give a good sense that they've been largely successful in that regard. There are certainly the challenges and stress-filled days and nights and often weekends of being a Superior Court judge is often daunting. The rewards are also present and make the effort well worth it. Each day gives me a chance to use my legal training to help others. Each day gives me a chance to make a positive impact on people who are going through some very difficult times. I know full well that there's a great public trust that comes along with being a judge, and I've worked hard to justify that trust. I continue to be willing to work hard and do whatever is needed in the future to preserve that trust. I know I'm privileged to be a judge in this great state, and I'm looking forward to an opportunity to keep going with that job and ask for your endorsement in that regard. One final brief aside, I would also take this moment just to invite you folks. I know next year, I think you'll be around again, and I know there's another set of judges that are coming up, but this fall and summer, certainly I invite you to visit the courts either remotely or in person, because I know the judges who are up next year would certainly welcome any observations that you have, and I can tell you that firsthand observation, not just looking at the cold statements, would be beneficial to you if you had the chance to do it. So with that.
Thank you so much. Senator Palmer, would you get us started?
I would love to. Welcome, Judge. Thank you very much for those comments. I did note that in terms of the attorneys answering the survey, there were only 2 negative comments. One of them has already been previously referenced with a letter that all the committee members received, and I'll give it according weight, I guess. And you just mentioned the only other negative one about possibly having favoritism toward the state or institutions. However, at the end of that comment, it does say, I do not see a reason to decline to retain the judge. So to me, that turned into a positive one. So you really only had that one negative. You had a perfect score and great comments from the staff. And the other thing I'll just mention, because I do actually read all this, when you were talking about the concept of equal justice, I found this very noteworthy, and thank you. And I know there are 2 senators to my left that feel the same way. I just realized that may be taken as a political statement. I didn't mean. You wrote, that can mean taking extra time to ensure that an immigrant who may not be proficient in English, like my Italian grandmother, has a proper translator and fully understands the proceedings. So I thought I'd mention that, and kudos.
Because we just to let you know how the translation system works sometimes. And you know, I had over a week trial of Mandarin. So we had both simultaneous translation, staggered translation. We had a little box set up so that you could follow along at the same time. So the technology is very helpful in that regard.
I don't actually have any questions. Thank you.
Well,
Hello.
I want to make note of your little quote here. I really enjoyed, you may be mistaken. And you should say it each time the jurist takes the bench to remind you to fully consider all aspects of an issue. Like something I do every time I touch a power tool, I look at all the things. To make sure they don't get put where they don't belong. But I'm starting to wonder, Tom, this is my 3rd year of doing retention, and it seems like more criminal judges than civil judges have been before me. I don't know if that's true without going back, but. Pardon?
People who sit in the criminal.
Yeah.
No.
I know, judges that are actually sitting in the criminal division versus civil judges. And I look at the survey and I see the staff of all was really good, but the attorneys creeping up there in the approval category a little bit more than I think some of the I would see in the criminal judges. And I'm wondering if that has to do with the judgment. But can you expand upon that maybe? Am I
The
the end result of the hearing?
Well, I think each docket has its own idiosyncrasies, and you know, there's a different, and oftentimes the lawyers aren't the same ones either. So you know, some of the folks that are in the civil division rarely appear in the family division, or the ones who are in the family division rarely appear in the criminal division. And so you don't see that many people doing everything. And so, you know, we're sort of, we have the same problem. You know, there's a little bit of a mindset. You know, when you're in Orange County as a judge, you're doing every day is a different docket. But if you're in Washington County or Baker County, you're sort of focused on one docket all the time. You see the same attorneys all the time. And you sort of get used to what the flow is of those particular cases. And I don't have an answer for why the results might be different based on a particular division. I do know some divisions are more contentious than others and lend themselves to sort of perhaps greater personal feelings. I would say that.
Thank you.
I really don't have anything to say, but thank you for your service, you all of you. And, you know, I don't know how you do what you do, but I also have an Italian grandmother, or had an Italian grandmother and grandmother. So I understand the language very too, but, and I do check the survey ratings. You only had one fair and all the rest were good. or good to excellent, so evidently you do a good job. So thank you for what you do.
I didn't want to go back to the mistake point, just to tell a quick story, I know it's late, but, so I was, they used to do the courthouses used to be closed in the summertime, so that people could do harvest and things, and they'd be reopening in the fall. And in Orange County, I reinstituted that for a few years. We would bring all the cases in and we'd call the court, and the judge would do a speech, and so the first time I went there, I mentioned something like that. I said something along the lines of, no judge is perfect, and I will undoubtedly make mistakes. And then the headline in the newspaper the next day was, new judge, I will undoubtedly make mistakes. Careful.
Thanks, Your Honor. I sort of chatted this with somebody last week, but I'm on the corrections committee, so I was really interested in the case you provided there, because it's the type of things we're dealing with upstairs at the moment. But I often feel like just doing the legislative work, we're sort of failing incarcerated individuals with maybe not being able to provide equal access to healthcare as you would get on the outside. And I think with the work you do, I'd just be interested in your take. Do incarcerated individuals in Vermont, you think, get equal access to justice?
Big question.
Yeah, sorry.
I mean, if you get a flavor of the opinion, you have to look. There are ways for them to get review in court when they feel there's not proper medical care being provided. And it's my job to sort of oversee that. So I don't want to necessarily comment on the specifics of that in a particular case. But I don't think the DOC denies the idea that they're supposed to meet that standard of providing that level of medical care. Does it take time? I know there's one case I know where there's been a long time trying to find an outside provider to provide a very specific specialty service. And at some point, I required them to provide reports every month, really, it's kind of unusual, of what their efforts have been to try to find that provider. But I know I'm about to lose my doctor's retiring. I know I've been trying to find one when people say how hard it is. So it's a problem that the state has in some ways too, but we do try to, and there are attorneys in the Prisoners' Rights Office, and that's really they do a great job trying to defend and prosecute the cases on behalf of prisoners. Where there is a claim, we try to get them in and try to see whether there's a denial of medical services that's, where it's not appropriate, or whether there's an argument. Sometimes there's an argument, you have to have a trial, where they might have an expert saying, this person needs dentures, and then the state might have someone saying, no, this is not a candidate for that, it needs to have these 3 teeth pulled. And then there's standards of care in the community that's something we have to figure out, have a trial on.
Yeah, that's great. Thanks very much.
Good evening, Judge Tomasi. It's good to see you. And I have to say, reading your file and hearing your statement tonight, it makes me really happy that I'm back on this committee so that I could see the full circle, because the sort of feel of your file this time and the comments and everything is so different than 6 years ago. And even though I was in the same room. But I just want to commend you for all of the hard work that you have done to improve your performance and get that feedback that you needed, and the support and the mentoring. And it really shows in your file and the comments and your statement tonight too. And I just want to say thank you for doing that work and being the example of somebody who can, get the support they need and make their performance improved for the good of the court system and the respect and, reputation of the judiciary too. So thank you. That's really great. I also really loved the cases that you included in your file, and it's late, so I won't nerd out with asking you questions about them. But I did really, really like the cases. This first 2 in particular, we get questions all the time about bail and conditions of release. And so I really appreciated reading that. And then the school district case was incredibly timely, given what we're dealing with right now in the building. So I appreciated reading that too. And also it's an elections case, which I think is also. Anyway, thank you and congratulations on that job well done.
Thank you.
No questions. Thank you.
I'll just ask one about, similar to Representative Casey, actually, when I read that you were part of the Committee on Remote Hearings, we've heard, there have been some reports, media reports about certain unfortunate incidents, I would say, involving remote hearings and incarcerated individuals. And I'm wondering if you have thoughts on, how we're doing in terms of providing remote hearings to folks who are in our prisons, and knowing that there's the judiciary side and the Department of Corrections side, and there is a need for cooperation there, and multiple factors at play. Just wondering, I would like to hear your thoughts, since you were part of this committee.
Well, we were focused primarily on advising what a new rule might look like that would allow remote hearings and what kind of standards there would be for that, which came up. So since then, we've been doing sort of follow-up surveys, trying to pull the bar and see where they're seeing some areas of concern and where they're not, what they like, what they don't like. And we're sending out a new survey, which we just finalized. I think it's going to be going out in March. So we'll have more information at that time. And I think it depends on, in some ways, which docket you're working in and in what ways. I enjoy, I'm a proponent of remote hearings as much as I can. Really, I'm more of a hybrid proponent because there are so many times in the past when we had cases where someone wouldn't show up because they had to go to work. We had someone who wanted to take care of their kids who wouldn't show up for a court hearing, they didn't take the time from their families. And this allowed them, instead of taking a day off of work, to go 200, wherever they had to go to court, they can pop in for an hour, take a late lunch at work, and then they can actually participate in their hearing and get more, as opposed to it being kind of posed hearings. I like to have that access to justice. I'm happy to have folks. There's certainly some hearings where it's not appropriate. And in the criminal docket, there's quite a lot of hearings where it's not appropriate and where defendants have an actual constitutional right to be there. And that's an important thing to preserve. And so I think that there's a real issue there about the handoff of cases where there's a remote arraignment, and sort of the attorney defending that case is then not going to be the attorney for that defendant. You want to make sure that there's something in place that would allow there to be a transition in place, so they have a contact information for that defendant, and it's not just in the ether without a contact. Some people are homeless. So there's lots of things that need to be worked out, and I think thoughtfully can be worked out. In the civil docket, unfortunately, a lot of times we're not able to do transports for folks. Or sometimes we're not able to even get WebEx connections. And so we can only do telephone communications. So that's a problem area. I don't know what the solution is. Maybe it's more transport, maybe it's more folks. That's probably a good question for the next gentleman coming up here. But I do know that there are circumstances when we've not been able to go forward with the hearing because we haven't been able to get a connection to the facility in the school.
Thank you. Any follow-ups? All right. Thank you so much for your time and thoughtfulness.
Thank you.
We will invite the Honorable Thomas Zonay.
The record, Thomas Renee, Chief Superior Judge, and cognizant of the time.
Don't feel that you have to rush, please.
One of the comments that was in my surveys noted that I like to always have a song, music, something important. As I'm sitting here, I'm remembering back 18 years ago when I first sat in this very chair for my third retention. The song that comes to mind is by a singer named Kenny Chesney, and it's called Don't Blink. And the song talks about how life goes by, you learn, you grow, and you appreciate things. When I was sitting here 18 years ago, right where Chair Arsenault was sitting, was a representative named Avis Jervis. And I was sworn in on March 1st for an unexpired term, which means I had to be retained immediately. I hadn't sat. I hadn't done anything. I was in training. And for my first retention, I'll never forget, she leaned forward, she looked at me, and her first question was, why do you want to be a judge? And I said, to make a difference. And she sat back and she smiled. She said, that's what we want to hear. That's great. And I meant that. And I've kind of used that as my touchstone as I've gone through. A couple of years later, I was in Rutland, and there was a case that came before me of a young man who was being held on bail. And he had come to court a few times for status conferences. His parents were there to support him. And they came up with a plan where they wanted him to go to treatment. And the request was, Judge, will you suspend his bail so that he can get rehabilitation and try to get the help that we think he needs? The state opposed it. I granted the request. He went to treatment. The reports came back after he completed treatment. They brought him back into court. He was successful. He did great. He was a leader. Everything that we had hoped would happen in treatment happened. And the state said, we want him back in jail, Judge, on bail. We don't think that he should have the opportunity to get out. And so I released him. I found there had been changed circumstances. The case goes on, and he comes back before the court, and the state took a different view of this young man because he had turned his life around. He was working. He was under the supervision of his parents. Life was going the way we all wanted him to go forward. And at his change of plea, I wanted to highlight for him that he was responsible for this. His parents weren't in rehab with him. I wasn't in rehab as attorney. Nobody but him was responsible. And I was highlighting, I looked and said, so you did great, yes. And when you're sitting on the bench and you see a young man or a young woman and you start saying something nice to them, you can physically see their chest come up, their head come up, and the pride they feel. And so I was asking him, you did this, you were successful, yeah. Was it easy? No, but you did it, yes. And we're going through it. And I'm getting to the big question, because I wanted him to recognize it. And I said, who's responsible for everything good that's happened to you? And he looked at me and he said, you are, Judge Selden, because you gave me a chance when nobody else did. That sticks with you. Every day I've taken the bench, that stuck with me. Were there days that I might not have been, things didn't go quite as well? Sure. But that's, and from that time on, for 15 years, I sat on the bench every day throughout Rutland, Brattleboro, Orange County, Caledonia, the Northeast Kingdom. I was in Essex, Washington County, sitting in all the divisions. And it was a learning experience. As my colleagues have said earlier today, every day is a learning experience. We have to take advantage of that. This is my fourth retention. And each retention you go through, there's comments that are made, and boy, they sting. Someone says something, you go, oh, but that's good. Because if we're not going to look in the mirror and grow, how do we expect the people that we're working with in court, I mean, and others we come in contact with to do the same thing that we expect of them? So I've always found the process to be something where, yeah, I get it. Let's work on it. And so I went through my last retention as a sitting all the time superior judge in 2019. Senator Hardy was here. And 2 years later, I had the privilege of being appointed to be the chief superior judge. It's a much different role than I had before. I won't sit here and I put it in my paperwork about the different administrative order 18 and all the different things we do, but it's not the same. I sit on occasion, but the majority of the work of the chief superior judge is administrative. It's working with legislature, it's doing assignments, it's addressing recusal requests, it's working with stakeholders, it's things that is making a difference in a different way, on a much broader level. When I first took the role, I thought I knew what the chief superior judge did. Well, 3.5 years later, I'm still trying to find out everything we do because it seems like every day something new comes up. And every day I wake up and I say, I love my job. It's challenging, stressful, it's long hours. I wouldn't trade it for the world because you get to make a difference. Many of you in this room, I deal with the legislature. I come over and you ask questions, or outside of the committees, you may have constituents who have issues and may have questions about the law. And what I found there is that we have a representative democracy in our state of people who care. You take the time to learn, to listen, you devote your time. And I join my colleagues when they say thank you for the service, for what you're doing for retention, but thank you for the service for what you're doing every day, because you make a difference. When we go through retention, it's about the judge. So it's me, Tom Zoner. But I don't view my role as being about me. It's about we. And the we is everyone that I have the pleasure of interacting with. The we is each of you and your colleagues here in the legislature. The we is the staff in the judiciary, my colleagues on the bench, the stakeholders, the citizens, everyone we come in contact with. I would be remiss if I did not say that the we, a major part with my role, is sitting back to my left. And that's Terry Corson's our court administrator. Because her energy, her support, her partnership makes a difference in everything that we do in the judiciary. We have a Supreme Court that supports our efforts. And again, we have a dedicated, really skilled trial bench. We're fortunate for that. And don't blink. When I think about that, I also think about who was there in the beginning. Back in January of 2007, that day Governor Douglas called to offer me the position. I was in my office and I wasn't home. My wife called and said, well, the governor called for you. I said, ooh, did he say anything? He said, yeah, he's out for a few hours. So I went home and I was, oh my God, the governor calls. Representative, the governor called me. I was all excited, my wife and daughter there. And I kept like bouncing off the wall. I would say it's probably the best example. And I said, well, what do I say when he calls? Oh my God, what should I do? And my wife looked at me and she said, why don't you start by taking the trash out? And I tell you that because she was there beginning. Her being part of the we, any success that I may have or that we may have doesn't happen. And as judges, we get the surveys, we look at what everybody says, but the reality is we really need support. We need support from all we work with, and we need support from our families. And after 18 years, I just think it's appropriate to say I've been very fortunate having that support, not only from everyone I mentioned, but from my family. Because without them, I'm not the judge that I hope I am. So the next thing I want to talk about was Criminal Rule 48. I couldn't resist that. If you have any questions, I'd certainly be happy to answer.
Thank you.
mix it up. I'd like to start with you, Senator.
Sure, I don't have a question, but I just want to say thank you for being vulnerable and for showing emotion, and you made me cry twice, so that's something. And also when you were talking about Terry Corzones, you forgot to mention the cookies, so.
That's a very good point.
But otherwise, no, thank you for all you do. It's much appreciated.
Oh, me, oh, man, I really want to have a hard question to ask you. So I might reserve my question now. I have really enjoyed working with you. You have always picked up the phone when I've called. I remember one time I called you about a constituent concern. And you were on a train, I think, or maybe in the airport, like about in the line at the airport. Maybe that was two different
There were
times.
two different times.
Yeah, okay, once you were in a train, once you were on a plane.
We need to get the automobile.
The automobile, the boat, maybe next time. So you're very accessible. And I really, really appreciate that. And I appreciate how you will talk through, concerns, but also the law with me and help me understand it and also how to make it better, because that's our job. And also the training issues. So I do have one question, and this is sort of, a follow-up on my question with Judge Shafritz. And our conversations about the training about opioid use disorder. So what other training do you, and there were a number of comments in these files of the judges about additional training related to Odyssey, for example, and how they could use more training in that. So I'm wondering, do you, first of all, read all of the comments the judges make about what they need? And then what other training do you think would be a good addition to what you already are doing?
So what we do for training, we have a judicial education thing.
Yeah.
We review not only the comments when we get surveys, but we talk to judges. We have monthly judge meetings, and there's an opportunity for judges to raise issues there. We have a judicial college that we sponsor in Vermont every year. And Judge Valenti is the chair of the Judicial Education Committee, sent out a survey. The survey asked all the judges, what do you want to have for trainings? We're currently in the middle of.
Did they all say Odyssey training?
No. Not everyone's, there may be camps on them. But we evaluate that as far as trainings go. You had asked a question about the issue of the courtroom, with Judge Shafritz. Now she runs a courtroom. We've had trainings on how to run a trauma-informed courtroom. We had trainings on how to deal with people with mental health in court. We've had trainings on procedural fairness, which all ties into these issues. But for instance, hearing Judge Shafritz, I wrote down a note, talked to Megan about what she has for ideas. And so we try to bring in ideas from judges about what they think may be good trainings to do. We are looking at, for Judicial College this year, the issues of substance abuse, opioids. That's an important one. We do, however, have the possibility of getting funds from the opioid settlement. If that happens, those funds are not available until July 1st. And so Judicial College is in this fiscal year. And so the idea would be, okay, well, we don't spend the opioid monies before. What we do is we have a special training for that. So we are talking about scheduling a training that's designed just for that, for the judges. And so we try to take up the issues as they are. For instance, last year, 2 sessions ago, the coercive control bill came out. We had a training at Judicial College that year on coercive control because it was timely with that. And so legislative actions also, what you will pass and the governor may sign, that also comes into play for our decisions for what may be offered.
Great, thank you.
I don't feel like I needed the book too much for yourself there, Judge. You're with us all the time up in corrections. And no, I just want to say I really benefited from the time you do spend with us, sort of a lay person on a lot of this stuff. But even though it's a bottomless pit of issues, you explain all this in a really accessible way, which I think is important, especially with our legal system. And you exhibit such kindness too, which I think, you're a rare man. And I don't have a question, but I just really appreciate everything you do there. And having you as the sort of face of the judicial system in many cases, I think we're we're well served with you as the ambassador there, so thank you.
Thank you, Your Honor. So, you know, you're like the manager of a baseball team. When they do good, you get some of the credit, when they don't, you get the blame, but you've got a good team. And I'm gonna give you credit for that because you're the leader. You take the responsibility for them, you work with them, you help train them, and, you've always been responsive, I know, to me, and I really respect you for that, so. Thank you.
Been a pleasure over the years. Thank you. I wish I could ask you a question and not get, oh, it's a matter of policy.
Policy
We don't need to. So I'll just pass it along. Representative Delay.
Yeah, I don't have any questions. I know, I mean, I've heard about you for, years, well before I was here, just, throughout attorneys that I know in Rutland, and just always have heard great things about you. So.
I also have no questions. You have my thanks and my respect.
Come on, ask him some.
About Rule 48.
I thought you were going to. Well, I feel very fortunate that I get to ask you all kinds of questions and do in committee and outside of our committee. And I think, like Senator Hardy was saying, I've always appreciated, we don't get training, we get minimal training, there's no handbook. We all come into our roles as legislators just like kind of guessing and hoping, and we rely on people like you in positions like yours. And since I joined the legislature, just 2 years and a month and a half ago, from the start, you were a person that I knew I was going to come to rely on very quickly, respect, and appreciate. And you help us do our jobs, which is incredible. Really makes a difference because we're passing laws that impact everyone in Vermont, and it's a heavy burden. And to have help from you and people like you makes every bit of difference. So I thank you.
Can I ask a question?
Yes.
So I want you to have to answer a question. This actually, Representative Casey did mention the article that came out recently about the access to the courts for people who are incarcerated. And it sounds like that's really not a good situation. I'm not on the Corrections Committee or the Judiciary Committee, but what are you doing to improve that situation so that there's better access?
What time are we gonna stop tonight?
You don't have to.
We have regular meetings with the stakeholders. For instance, next Monday, we have a meeting scheduled that is a regular meeting with the Department of Corrections, with the state's attorneys, Inspector General, and judiciary, including trial court operations. We have stresses right now on the system because we have transport issues. They're down transport officers. We can't get transports to the court for all the hearings. So we have remote hearings. We're trying to rely on the Department of Corrections. They have pressures and they can't get all the hearings done that we would like. The Department of Corrections says, well, they will do hearings for certain criminal cases, but they won't do hearings for other types of cases. And so what we're trying to do is come up with strategies to maximize what we can get. It's not the fault of one agency who's saying, we just don't want to do something because. It's the reality that everyone is feeling pressures. And what we need to do is recognize that Newton's third law applies here. And that is, for every action, there's an equal and opposite reaction. For putting pressure on the courts, it might have pressure on DOC or the sheriffs. If you take pressure from the sheriffs, it might have it on DOC.
Are attorneys not going? Because that was the other thing.
There are comments that have been made, and I'm not there, but there are comments made that attorneys are not showing up in court, in jail to see their clients as much as they otherwise would. That attorneys are sometimes trying to wait for the person to come to court on their transports in order to see them. And what we're trying to do is maximize the appearances in court that are in person, while also recognizing that we have to have a balance because there's times that we have to do remote hearings. Right now, Defender General is under significant stress to find attorneys to be able to take on cases. He's doing contracts with people who might be in Chittenden County as their primary location. They're coming down to Windsor, Rutland, Bennington to pick up cases. That helps us address the backlog. But those individuals can't show up for court for every hearing. And so those are hearings that we'll do remotely. But then that puts a stress on DOC because DOC says, well, wait a minute, we don't have the people to be able to do that. So we recognize that. And so we've been trying to work with the Commissioner of Department of Corrections. There's been times that they have set out policy saying, well, we're not going to let you do this type of hearing. And we've gone back to them and we've discussed it and they have expanded it in some areas. And so we greatly appreciate that. But the difficulties that you read about are ones that there's no simple answer to.
Yeah. Well, let us know if there's something we can do to help.
Thank you.
Yeah. Thank you.
Thank you. I believe we are adjourned.
Need a motion?